Okay, shall we get underway? Having had a nice break. This is a case, an example case from New Zealand. I've decided that we won't go to that now. It's better for us to move on through the other steps first and then come back to this. And I also want to do in the last session tomorrow, because tomorrow morning you'll be sent out a case study called Bala, just for the name, a Sri Lankan case, which Sujin will send out to you all to read, and it has attached to it not all the COI this is an actual case, and in fact it's that actual case. That's another reason for not going through it now, but and so you can read through it if you get half an hour tomorrow and see the questions that are in it and what you think about them. And so when we come to the last session about this time tomorrow, hopefully we'll all have to go to sleep, but we can have a look through that case, and then we can come to this decision here right at the end, and you can see how a judge in a New Zealand case some years ago wrote the case and wrote it down. It's because it's just an example, but it happens to be an example of a judge that writes extremely clear decisions and has got very good reasoning powers. So it's a very good example in not too many words, where, I don't know, it's about 12 pages long, I think, but he pulls the whole thing together and you'll see. But anyway, read through the Bala case. It's quite a big chunk of international crisis people that have done the COI, but it's highlighted. So just read the highlighted, but you don't have to read the whole lot. It's really, I'm trying to get a fairly complex case down to a fairly small one for you, and so it's better to use a real case. And then when we've finished that, we'll pass out to all of you as students, not the auditors, but to look at two other cases, one very simple one a little bit more complex, and that's just, I want you to do about 1,500, 2,000 words, 1,000 on each or something like that, or maybe 750 on one and 1,500 on the other or something like that. Bullet points really don't have to be in beautiful English or something, just what are the key points, and that's, if you bring that back, I think in about 10 days, we'll mark that for your course, and the second one we're not going to mark, it'll just be participation and attendance, and generally you've all been good participants, so I think you'll all do well on that side. So anyway, so we'll do that, and that'll be the way of assessment. All right? Yeah, okay, the last point we were making really is the so-called residual or benefit of the doubt. Okay, what happens is, you've seen as we look through credibility that it's not easy, because you're dealing with so many factors of evidence, languages, all these things that make it hard to pull the whole thing together. You just do not have, like you would have in a criminal or a civil case, you just can't pull people in and cross-examine them and get the information. It just doesn't exist. And on top of that, you're trying to predict the future. Wow. So you put all that together and you think, no, you can't. It's much, much harder to get to stages to get to firm acceptance of what the person you're assessing and what their risks are. So that's why you get judges and others saying, like I said before, may have happened, or this might have been the situation. Those sort of conclusions are useless, because you can't really be definite about what you're doing. So, thus, this concept of residual doubt has come in. And this is the UNHCR standard. I have to tell you that a lot of countries don't like this very much and like to be more firm in their approach, but this is the fairest way of doing it. So the international standard mainly put forward, originally came from the UNHCR, and it's in that book, When residual or remaining doubts are held by assessors or judges in the assessment of some parts of their claim, not all of it, of the claimant's presentation of past and present evidence and circumstances due to unsupported evidence, in other words, it's not supported, it's just their word, parts of it give you concern. Prima facie, that's on the face of it, where all the other evidence is accepted as credible, the benefit of the doubt principle should be applied to those parts where you have remaining doubts. So let's say you accept about 70% of the evidence, you've got doubts about some other pieces of it, then the correct way to assess it is give the benefit of the doubt on those other pieces of evidence if you can't quite make up your mind. And you can imagine that because so many pieces of this jigsaw or the puzzle you're trying to put together are just not. You can't get them and the certainty of evidence that you can get in civil or criminal domestic cases where people are available, you can subpoena them to bring them in and so forth. You can't subpoena the government of Iran to come up here and give evidence. You can't, and you just wouldn't do it and it'd be utterly unreliable. So that's why that principle is there. And it is, the other thing is, it is only the credibility of the person's evidence. It is not something you use when we come on to the risk on return. And a lot of people confuse it. This, otherwise, if you did do that, as actually was pointed out to me years and years ago by a Japanese judge when I gave evidence in a case here about 20 years ago, where he rightly said, if you do that, you're lowering the standard twice. You see what I mean? In other words, if you're prepared to give the benefit of the doubt on part of the evidence and what you accept about the claimant, then when you come to the risk element, surely you're adding another factor to lower the risk to too low. It's a bit hard to grasp until we've been through the risk test, but anyway, that's another reason for going on to it in a moment. So that's what the benefit of the doubt, but it only applies to credibility assessment of the evidence of the claimant. It is not for assessing how serious the risk of being persecuted is. That is another test done on the totality of the evidence. All right? Okay.
Do you understand the benefit doubt related to technical things?
Do you understand the concept of it?
Huh?
Anybody who doesn't understand it? Any questions about it? You see, if you're an advocate in it, you may know that it looks as though there might be some doubtful bits. You would plead this as a point to put up. If you're a judge or an assessor, then you take it into account. But if you're an advocate, you'll be always pressing this, and it's sensible to do so, to make, to enhance your client's case as much as possible. But don't use it for the totality of the evidence. In other words, you've got to be get your client's evidence should be as strong as possible without going crazy on corroboration and things we talked about. But don't just ask for, he should get the benefit of the doubt. There will be things that will lead to that, but that's not the first thing he should be arguing. All right? Okay. Sorry, yes. No, sorry. Using percentages in this field is dangerous. Highly, highly dangerous. And when we come on to... it's just... it really is materiality. If a lot of the material points you've got to be confident you're able to accept. If you've got, say, one or two that you're not happy with, and actually when we come on to see that case, that's why I've given it to you, it's a partial credibility acceptance. You will see how you deal with that. He didn't actually need to in that case, but in a lot of cases where you're left with one or 2 points, I can't make up my mind, and the evidence is not there in the country evidence or something like that, then that's the case for using the benefit of the doubt. to get what you just can't quite reach it. Okay? Yep, right. So just to quickly go through some summary. Pragmatic approach, in other words, don't get too stupid about what you're trying to do. Remember to look for the totality of the claim. And if all is accepted, the next question must be, after you've got the profile of the person, you then move on to the risk on return. But if you haven't got it, the profile, in other words, or characteristics, you don't know what to assess for risk at that stage. So it's a must. That's why the steps are set out there. Good credibility is a combination of knowledge of the COI, all facets of the claim, materiality, as we just said, balance, the most important thing in being a decision maker or a judge, or even the advocate putting the case forward, and prompt, not let it lie around for years because you'll forget what the case. Most courts now insist that you have at least a draft of your decision done in this field within a month or 3 weeks to a month. The UK used to have a rule for many years. If you didn't publish your decision within 3 months, the courts, you could make a claim and they'd have to do it all again because you just cannot remember, particularly if you're doing 4 cases a day, as they do in the UK, and you seem just a jumble. Anyway, good quality RSD and assessment is vastly assisted by fairness, prompt processing, and get it right first time attitudes. That's the businessman in me coming out all the time, but that's really, it works better if you do it quickly, promptly, and fairly. And at the end, you have a fair removal or deportation system for failed claimants after they've exhausted every appeal right, including so-called suspensory effect. In other words, you don't kick them out of the country while there are still appeals going on against their removal. All right? Okay. Yeah, we just 1 minute. We'll go to the end of that. We're going to give you a quick run through this on COI. And I think if you go about, the main point is that there's a shared burden because it's so hard to get, and you will realise, of course, that it's very hard for a claimant with no money, not much education often, and no ability to get it, to bring any assessor a whole lot of information. So the shared burden thing is really that I talked about before, that if there are protection points in a claim or in a hearing, then the judge has the right to intervene in many countries in it. And there's nothing wrong with the court going to a COI like CDR and getting information itself, but you must put it to the other side for comment. All right? Right, so you can just go on from that and just go to the list there. Right, there are some guidelines at the end of that paper you've got, and these are quickly. How relevant is the COI to the case in hand? Pretty obvious. Does the COI source adequately cover the relevant issues? In other words, is it relying on good information given by a reputable organisation like Médecins Sans Frontières and places like that give evidence to support it? How current or temporally just means at the time relevant is the COI? The source of the information, is it sourced? In other words, and good COI, you'll see the reports show the sources that their comments come from, and usually it's in a schedule at the back of where all the information. In other words, they're not just plucking things out of the air. If you look at a good Human Rights Watch or UNHCR one, it'll do that. The information, this is very important, the COI is publicly available from accessible sources. So you can't just go along to the Foreign Affairs Department and say, give me all the information you've got on such and such a country. And they'll say, well, a lot of that's confidential. And sometimes, sadly, countries do give it to their judges and so forth. Well, you can't use it, or you should not put it, you frankly shouldn't ask for it, because it's not publicly available and it's grossly unfair for one side to have the information and the other side not to, for the claimant. So that, and if you feel that you have to, then there are ways of going through it to ensure the confidentiality or security risk perhaps to the country involved is not impinged on, but yeah, it happens. I've had it happen perhaps 3 times in my career. You've got to be very careful. And there are precedent cases to tell you about that. Yes. You're talking about, for example, some terrorist or some group which, or could be even drug smugglers or anything like that, where your government may have information, confidential information to itself, about how such a group works, or gang works or something or other, and that they're at high risk and what they do and what they don't do. But they won't disclose it for fear of ruining a worldwide breakdown on them or something like that. So that if you disclose that and that this person was, for example, likely to be a member of it, it's a very delicate information. So on the one hand, you feel as though you're better without it, but on the other hand, it could be highly relevant for exclusion. You see what I mean? And so you've got it, and sometimes you even have to get counsel in and say, I'm going to give you some information, and you cannot, and unless you agree not to disclose it, and so forth, then we won't use it. But if you agree to it, from fairness, and then it's the council's responsibility to the court, which I presume they have here, as certainly is the British system, because you're an officer of the court, and if you did breach that, you could be struck off as a lawyer. So you go through those. I'm getting right into a lot of detail, but anyway, let's go. The COI has been prepared on a very sound basis, and that's why you look to the good reputable ones. No, what I'm saying is, well, usually they won't give it to you anyway, so if they've got any sense. But in some occasions, particularly when foreign affairs often in a lot of countries used to run this is 20 years ago or more, used to run the refugee system, they would use information. The Australians were pretty bad at that at one stage. They would use this confidential information to push down to strike out a claimant's case without really disclosing it, that they had it to the claimant. So you can see the fairest way to do it is A, not have it, or B, if you feel you must disclose it, you've got to go through some effort that does not give away the secrecy or the of the information, but on the other hand says your client we have reason to suspect your client may have committed some serious offences. You've got to put it in very different language. Then, and I'm going to ask them about that. And if they deny that, you haven't actually said what it is, but you've skirted around it. You probably then would not publish that decision, or you would redact from it the strike out, blacken out the part that may have even tended towards disclosing where it came from. But yeah, this is unusual, and so and very specialist area. Okay. The other one, impartiality and independence, and again the COI is balanced, both sides, and not over selective. And then finally, as there been, in other words, this is like judicial scrutiny on same thing by other courts, and that is, the best example is the British system, where thousands and thousands of cases we had there, and because they were from countries such as Sri Lanka or, in fact, hundreds of countries, African countries and all sorts, we would set up what's known as a country guidance case. And of course in London, you can get experts on anything because all the universities are close at hand. King's College was next door. University College London was just about 50 metres away. Oxford's a 1 hour drive, a 1 hour train ride. So you could get all these experts, or so-called experts, some of them, to come and give evidence and cross-examine on what the conditions are in Palestine or wherever it might be. and then you can borrow that in another court somewhere else in the world, here, there, or anywhere, and it's only just guidance, only just, somebody else has done the work. And a lot of those sort of things where it highlights the areas of risk have been approved by the highest courts, like the European Court. I wrote one just before I left, 2008, I think it was, in UK on Sri Lanka. And it's about 70 pages if you want to read it. And it distilled from that the high risk areas from all these experts and so forth. And the UNHCR, in fact, some of it material came. Anyway, then that was published and used by thousands of other cases that were waiting to go through. It was put to them and said, are you any different from this? Which meant the evidence in those cases is much, much quicker done, and 3,000 in a backlog quickly went down. So that's why it used. And that case, along with another one, was taken to Strasbourg, to the European Court of Justice, and they approved it and said that's the right way to do it. In a case called NA, and that now has been taken as sort of very widely spread guidance on COI. Okay, that's it, okay? So, we won't go through that anymore. It's merely the same thing over. There's more in the notes that just go on for about 4 or 5. It's really saying the same thing twice. So we're now going to move to the next, we're getting to the bottom of the page, to step 3, which we call the harm box. And that comes in now rather than the risk, because, as you can imagine, if the harm the person fears is not serious or a substantive breach of international human rights, then it will not rise to the standard of being protected. So if that's the case, there's no point in looking at the risk. The risk may be mere discrimination or something that does not rise to the level that's protected. Okay, sorry. It's a very good question. It depends on the person, obviously. And it depends on, really, I have to say, the level of counsel or legal aid and so forth that's available. There are, like everything, competent lawyers and utterly incompetent lawyers doing the work. Unfortunately, because legal aid in nearly every country is chop down, or do you even have legal aid here? I don't think you even have legal aid, do you? Do you have legal aid for refugee cases?
Yes, but very tricky things is, because we also got the public funding from the Ministry for Justice, under this scheme. It's especially illegal overstayers or anyone, each one wants illegal stay, it's excluded. So, Bar Association, Japan Federation Bar Association, provide some sort of a special assistance.
Do they? So it comes from the Bar Association itself?
Yeah.
Okay, not from a government-provided legal aid. Well, we don't need to go into detail, but
government will provide basically, in the principle, if it's a legal stay. Yeah, that is the logic, because you are no longer allowed to stay in Japan. So in this sense, no access to the public funding. That is a government logic. But if you are kind of student visa valid, or you have not overstayed, you apply for refugee status. In such case, you can get some funding for the assistance because your stays are legal. So.
Yeah, but if you're an asylum seeker, you're presumed to be a refugee. So
yes, I know.
How can you be in the situation of not getting legal aid?
Logically.
Not logically, that's the law.
Yeah. But,
anyway, I'm not going into an argument over that.
This is one issue.
That seems somewhat incongruous.
Yeah.
Okay, there's a sort of halfway house. No, I don't think we need a debate on this all night. Otherwise, we'll never get through it, and it sounds highly complex. Anyway, but to answer your question, is we've just seen the problems of legal aid or lack of legal aid. But even with legal aid, I have to assure you, in countries, New Zealand, UK, lots of other, the legal aid is so low that it's very hard to get lawyers to go into the business. And some of the best lawyers you've had in both those countries, both my experience, as you asked, don't do the cases because you simply cannot run it for the legal aid you get. So the task is not easy. And therefore you end up with bar associations or dedicated lawyers, or even the big firms, fortunately, who seem to be getting better at it, will do pro bono cases. And the pro bono cases here, I think, often cooperate with JAR and so forth to learn what it's about. Or they get in touch with their father and ask them a bit of advice on refugee law, as my son did. He's a guy Ben here. So it varies, highly variable. Therefore, you can see again the decision maker and or judge doing those cases often will have to get, as we say, into the arena. If there's truly, you can see this looks genuine, or this looks like something that we really need to look at and ask the questions themselves. And so hence where we're asked as and that's the European system, that's the civil system, the Japanese system, the German system as well. So the judge can get into the arena and investigate the case themselves and ask the questions. So it does fulfil the burden of shared duty of looking into it. So it's a mixture, but it's not perfect. And I'm sure there are lots of people who do not get their cases done well through lack of representation in presenting it. So yeah, I just cannot give you, that's the world. That's what happens. And in poorer countries it's even worse. So that's, and sometimes the UNHCR is all you can fall back on and hope that they will assist as the ultimate course. But now they don't even get the money either. They're getting their funds are non-existent. I don't think the Americans have paid for quite some time. We have to be thankful the Japanese is probably the best payer of the lot. So don't be critical of the Japanese system. It's one of the biggest contributors to the UNHCR. And so, there may be things we've got talking about the law here and so forth that are different to other parts of the world, but their contributions and their generosity is fabulous, and comparatively, perhaps I put comparatively fabulous, because for some reason countries, this sort of anti-migrant, anti-refugee thing. Okay, let's come to what's simply called harm. What's going to happen to you when you get home? And this is a quote from a famous British decision called Shah, and it was heard with another case called Shah and Islam you'll often hear about. And it's the famous case that decided that women could be a particular social group. It's the same case. Anyway, it's a highly specialised field of adjudication, and they're talking about the lower level tribunal. There's two tribunals in London. In UK itself, it is the adjudication, they used to be called adjudicators, that's why they're using that word, is not the conventional lawyer's exercise of applying a legal litmus test. You know what a litmus test is? Chemists? Who's the chemist? And do chemistry. One of the first things you do is put a piece of paper into an acid and you see whether it turns red or blue or red or green. That's the litmus test. Oh dear. Education, not scientists here. So in other words, it's not a legal litmus test where you put it in your question mark box and find an answer to ascertain facts. It is a global, that's what I said, in the round appraisal of the individual's past and prospective situation, looking to the future, in a particular cultural, social and legal milieu, nice French word, in other words a mixture, like a soup, judged by a test which, though it has its legal and linguistic limits, has broad humanitarian purpose. It's extremely good English, I have to say, written by an extremely good judge, who I think is about my age and still a member of the ILJ, Sir Stephen Sedley. Stephen is probably the best judge that refugee law and this area has ever had. So, and he was a good communist before he took up the bar. Anyway, we're all allowed problems in our youth. Right, so that's overall. Right, harm. So in the Refugee Convention, the words are being persecuted. They're not persecution. It's not the noun. It's being persecuted. And into the and what happens in the CAT, because it's again relevant, torture. Torture, inhuman or degrading treatment, as it is in the ICCPR. So there's 2, 6 and 7 in the ICCPR. 6, arbitrary deprivation of life, and cruel, inhuman or degrading treatment or punishment. And there's books and books of law on just those words alone. All right, next one. Persecution is not defined in the Convention. Therefore, it has to be read in according to treaties such as the VCLT. In the spirit of good faith, Article 26 of the VCLT, giving the ordinary meaning of the words, and that the context includes the object and purpose of the legislation, Article 31. And then the terms, which is unfortunate problem really in various countries, where people tend to talk about persecution on return. And the problem with, you can see the problem with it? In using the word persecution, this person has a fear of persecution when they are returned. What's the difference between that and this person has a fear of being persecuted? Can you see the difference? It's a nuance in English, but it's an important one. I think it's exactly the same in French. It's the same nuance. What does being persecuted add to the meaning? You're absolutely 100% correct. Very good UNHCR officer. That's the difference. The emphasis is on the predicament of the claimant rather than the actions of the persecutor. Because if you say, I fear persecution, well, who does the persecution? What is persecution? It's a generalised state or existence. It does not personalise the claim to the person in front of you. And that, frankly, you'll see it not just this country, all around the world. Judges and others write about the fear of persecution. No. That's not what the Convention says. And they all go on and say, it's a generalised state of confusion. Well, that is much, much harder to prove or establish and understand than this person in front of you and the risk of them being persecuted on return. So you're going to look at objectively the characteristics of this person or somebody of their nature being returned and being at the risk of being persecuted. So it personalises it to that claim and that person. Whereas if you just said persecution, that could be, there might be lots of persecution going on in the country, but nothing to do with the person you're dealing with. So it's language, but so the passive sense is, as I said, both in English and French. That's what being it's called the passive tense, if you remember your grammar. Right. So being persecuted, what is being persecuted? And these should fall down. That's it. Being persecuted is serious harm. This is arising from sustained or systemic violation of internationally recognised human rights, demonstrative of a failure of state protection. Understand all that? And so, if a basic human right is being violated and the state cannot or will not provide protection, this is being persecuted. So in other words, you've got to have the risk of being persecuted, and because this is all about surrogate protection and state protection, the state will not do enough to stop you or lower the level of risk to you below a real chance that it will happen. So that's really, that's the New Zealand definition of it. It's pretty similar to the British one, and a little different in Europe because they used the word persecution instead of being persecuted in the European qualifications directives, much to our horror and much to submissions put in by the IRMJ to not to do it, but they did it anyway.
So that means not necessarily the prosecution will be made by the authority or government, just be private persons.
Yeah. So you can have non-state actors, what's called non-state actors of persecution or state actors of persecution. Doesn't matter. In the end, if your state will not protect you from non-state actors, you're still getting persecuted. In other words, like the Russian gangs are a good example. Often they are, you have to find the evidence, supported by the local police force. And in fact, the police force are the main members of the gang. So they enforce this, and you cannot get protection from your own state. So therefore you have then they're pretty horrific what they do. And so that your basic human right to life or other horrible circumstances is being violated, and the state is not protecting you. Yes, we'll come on to that. If you remember, we looked at Article 1A2 and it said being persecuted for reasons of race, religion, members of a social group, nationality, or political opinion. 5. So we'll come on in a minute. In other words, it restricts you to just those reasons, but the definition of those covers quite a lot of ground still. Okay, next one. What is the justification for looking to human rights instruments, which we talked about, for the meaning of being persecuted? So, international human rights norms already define what harm is. So why make it up, if you have the right to make it up, country by country? Because as soon as you start making it up in your own country, you're then taking away the whole consistency and cooperative nature of the of refugee status, and so you're going to get, that's what causes in one country to recognise and not in another. So it's particularly unhelpful and wrong. Human rights are explicitly referred to that's what I was talking about before, where this all came from when we were discussing human rights and whether the convention fell within those. They're referred to in the UN Charter and the UNHCR. Have affirmed the principle of human beings shall enjoy fundamental rights and freedoms without discrimination. So to look at the treaties is totally consistent with the purpose of the convention. So that's why we often say it is a human rights instrument, or it's near a human rights instrument and highly relevant to it, and they must walk together in the interpretation. And it's pragmatic, which is a good one. And it's also the same evolutionary factor of human rights has taken place as has the living instruments they are, as with the Refugee Convention. So it moves with the times. It is not human rights which evolve, but our application of them across, that's right, society and cultural changes. This has allowed refugee protection to be granted for reasons not explicitly mentioned in the convention. As I mentioned it before, when we were discussing this, such as sexual orientation, gender, they were never dreamed of, I think, in the 50s as being something that would get protection. So the convention thus remains a dynamic, evolving document, living document. Why do we use human rights as a yardstick? Instead of the rigid application of predetermined forms of harm, in other words, dictionary definitions or such things, which will be variable, decision makers are able to consider the nature of the right, the human right that you're looking at, whether it's higher or lower. Hathaway had a hierarchy of rights, which is a bit dangerous to use, but it puts them in levels. That's in that book I showed you yesterday on refugee law. The nature of the restriction as well as the seriousness of the harm, in order to understand whether the person is at risk of being persecuted. All right? So the other thing about human rights, it's universal. There's a universality of using them. So therefore, it's a large step towards consistency on an international basis on what, after all, is an international instrument. So we've gone through this. They're to be found in such, in these ones, CAT, ICCPR, CEDAW, and many others. Social, cultural and religious practice do not escape assessment according to international standards. So in other words, just because religion tells you this thing, no country can defend human rights violation by hiding behind domestic law, custom or tradition, because it goes back to these core human rights convictions. So you can't come in, we can suppress women and put them in burqas and not educate them as they did in Afghanistan and so forth. That is a clear violation of human rights. And it's not just because you write it into your law or custom, it doesn't take that away. So they've been widely ratified. It doesn't infringe on a state's sovereignty, as I said before, it's apolitical. It provides an objective standard separate to domestic laws and morality, which is good because you're then getting a very independent view of it. And it's also, again, apolitical because it's part of an international regime that you've signed up to by signing the convention. And as I said earlier on, if countries don't like it, don't sign it. It's that simple. But it avoids political judgments and other practices about another country, again, in reinforcing the apolitical nature. And it means the convention is flexible and can respond to new threats to human dignity. That's where we started yesterday. Okay, so rights-based approach, so-called non-derogable rights, that is ones that you cannot opt out of when you sign the convention. They're so serious that they're non-derogable. You can't take them away. Like protection against arbitrary deprivation of life, cruel, inhuman treatment, etc., are clearly at the top of the list. Other rights like religion, the right to religion, private and family life, rights under the ICESCA, rights to work, housing. You can persecute people by just making it simply impossible for them to work, nowhere for them to live, nowhere for them to even get a feed or get on with their life. And then if you, like the Rohingyas, if you then take away as well, burn their houses down and give them and make them stateless, you're definitely persecuting them. And you're breaching a number, as the Burmese were, or Myanmarese are breaching a number of international human rights. So we look at the international bill, or the ICCCR, and these ones first up. You'll find another in the Convention on the Elimination of Discrimination Against Women, highly relevant in a number of these cases, and the Convention on the Rights of the Child. That's a particularly important one, and you must start every case. You should start there almost immediately after the Refugee Convention. Look at the CRC and you'll find out the way that children can be persecuted, particularly unaccompanied minors. There's all sorts of guidance from the UNHCR on minors and how they're to be treated. Okay, but as I said, primarily on a day-to-day basis, the instruments you go to are ICCPR and ICESCA, and you look back at the UDHR. You will find that when you look at a lot of, they don't actually say that because it becomes so innate, so much part of your decision making, you don't go back and look at it because you know that's what it is. It's only when you get sort of fringe cases that you will go off and look at the totality of the human rights that these things will come out. Okay, so what leads to it? So you need 3 elements: serious harm, arising from a breach of the right, and the absence of state protection. And then there's that famous piece of algebra at the bottom. You understand what that means? Persecution equals serious harm plus a failure of state protection. Okay, and that was something that in some women's forum in about 1999 somebody came up with. And judges then have started adopting it and saying, this is brilliant, this puts it all together. So you must have two limbs. You cannot just have the serious harm, you must have that, and you must know the state, because it's about surrogate protection, that your state is not going to protect you or lower your risk below that of being a real chance or a real risk. Okay, do you understand that? Just while we're looking at that, the P equals SH, and so when we come soon to the convention reasons, you can have, the convention reason can be to either serious harm or failure of state protection. It's a little bit technical, but for many years, and that's how women came to be a particular social group, because you would often have this, but you couldn't prove that. And so the convention reason can attach to either one. Or you can have, as you had in Iran and Afghanistan, you had this, where often this was harder to establish. So the link can be either. That took us about, because we debated this question, I remember, in New Zealand, for about 3 years it took us to work that out. So there's a lot of thought goes into that. We used to have training meetings on Saturday mornings, and was main topic for discussion was often this. Okay.
Well, I think these serious harms also have a lot of room for interpretation of how serious it is. It's also depends on the kind of perception of the, how what is the level of the seriousness is also be.
Yes, it is, and that's why we've said in here it's primarily the high-level rights that you have in things like the ICCPR and so forth. But again, and it comes from the quote there, comes primarily from Hathaway's that he wrote back in about 1989, which was amazing to get to that conclusion then. But sustained and systemic. It's going to be very rare that you can, for one incident, it can be, but it's so in other words, it's something that should be, the lower the level, the more sustained it can be. So you can have lower level for 20 years, for example, as used to happen with groups around, for example, what do you call them? The Hill Tamils were treated disgustingly, but more at the level of discrimination, but they never in Sri Lanka were able to get out of that, and so that often was, certainly the UNHCR recommended it, and there are a few cases where those people were recognised as having sustained and systemic. It didn't go on for 2 weeks, it went on for their whole lives, and so that was seen to be serious enough. There is a judgment element in it, you're quite right, but and that's why when you get the cases that are on the margin, you have to put a lot of effort into it as to whether they actually, and it's the whole point here, whether they get to the level of seriousness, because if they don't, then you can stop the case. You see, that's the end of it. It's what we call mere discrimination or discriminatory discrimination only, and there's plenty of cases where it is just discrimination, not to a higher level. This whole convention was designed to have people the right to flee serious harm, not low-level harm or discrimination. No country can do that. You just cannot protect your people against every piece of harm you can think of. It's utterly unreasonable to think that. And so that's why it's serious, but to get consistency, you look to the human rights instruments which give you, it's all done for you, and it's not done just by, so there's a measure, a whole measurement thing is made for you, ready to use, and the Refugee Convention fits within it. Okay. No, this is the risk. This is the risk on return to them. You may have had it in the past. That probably strengthens their case, but it's not essential. It's predictive. This whole case, the whole job to do is what's happening in the future. So when you assess the case, you're assessing it as of now, looking to the future. Okay? Is that hard? Yeah, so when does you've asked the right question at the right time? It's a matter of judgment, but what degree is it, impact on human dignity? Is the harm of sufficient gravity? The point that Sato Senso has made, that surrogate international protection is required. The duration and intensity, we talked about that. Particular characteristics, and this is important, especially vulnerabilities. You can have, for example, disabled people who are so ridiculed and so badly dealt with, left on the side with no money and no treatment, that their objectively assessed harm to them is persecution, or at the risk of being persecuted. Right. Absolutely. So it is still an objective assessment of what happens to such people. But it brings it back to where we started. It's about being persecuted, which takes you to that individual assessment, not persecution generally. And it's a very good point, because that's how those cases, people can be predicted, like freedom of speech for people in countries where they're going to be suppressed and maltreated because of that. The state protection, as I said, the other side of that piece of algebra. So the state protection does not require a state to be an agent of harm. In other words, you can have non-state agents, can equally be an agent of harm. And there are four variations: persecution committed by the state, persecution condoned or allowed by the state, persecution tolerated, they'd say we don't like it, but they don't do anything to stop it, persecution not tolerated or condoned, but for which the state refuses or is unable to provide protection. And that is somewhat the most difficult one, the unable, because it's very hard to get good evidence on that, what is unable to give protection. So in a lot of countries, we rely on, therefore, the risk test at that point to say whether the risk is high enough. But anyway, so there's always a presumption of state protection. Absent some evidence, the claim should fail as nations are presumed to be capable. That's a very, very famous Canadian case of Ward, which was sort of the leading case in refugee law for about 10 years. Right. In rebutting, in other words, taking away the presumption, the question is whether the state protection will reduce the risk, and this is the key to it, reduce the risk of serious harm below that of a refugee of a real chance. Okay? And that's the New Zealand case, and there's a few other countries that follow that. The Europeans, unfortunately, I think for political reasons, have this test of reasonableness. I hate the word reasonableness, because reasonableness means what anybody thinks it is. It's too subjective. It's not a good test. Anyway, they say, for example, they had trouble with Czech, the treatment of Roma, the gypsies, as they're called, or the Roma. Rom is the correct name for it, in Czechia, or Czech Republic. And they said, but we've got lots and lots of policemen, and therefore you're not at risk. The state is providing it. But it doesn't reduce the harm to Roma below the level of a real chance or a real risk. So, but they've taken it into their law because it was too embarrassing when the Czech Republic joined, this is the reality, joined the EU to say that countries like, wasn't just Slovakia, a number of countries were doing it to them, Bulgaria and others. They weren't doing anything. They still treated them abominably. If I had more time, I'd tell you a story of going to give training in a prison camp in an ex-uranium mining town in the Czech Republic. And the only people who lived there were the Roma, who were kicked out of all the cities and sent off to these old Soviet tower blocks to live with their dogs. And that was about all there was. Anyway, the extent to which state involvement is relevant, because if the state's the persecutor, obviously the absence of protection is presumed. Where there's a non-state actor, an absence of state protection will need to be established. So you have to go, that's what we're talking about. And in summary, the development of the concept of persecution and refugee, there's a PowerPoint that's I don't know who that guy is. And Judge Story, a friend of mine from London, we did that. I don't think we need to go into all that. It's a presentation we did in 2014, I think in Gothenburg or something in Sweden. Okay, that's it. So we've gone through all of that. Yes, now questions. Yeah, no, they're very good cases, honour killings, and we had hundreds of them in London. It again comes back to the being persecuted point, that you look at the individual, and if it is the son, and there's enough history to do it, it's quite a you've got to get quite good evidence that that's going to happen, and it depends really on whether there is any chance of the police or the people that are doing anything about it and stopping it. And a lot of them did get refugee protection for that, and a lot of them didn't. So it's very much fact-driven, I think is the best way of putting it, as to whether the state protection was at a level that took it below a real chance. So that's what we said. I said a bit before. It comes back to the next test we're about to talk to, whether it's well-founded, the fear. What we've done here is define the harm. The next thing we need to do is to say, is there a real risk of it happening? And that's the point you've just raised, which is very good. Okay, how are we going for time? We've got time to do a little more. Is there any more questions at this time before I move on?
Yes, please. Here.
Yep. I was going to do internal flight as the last, or relocation, or internal protection alternative. There's three names. I was going to do that as the last point when we finished it, to tidy up. It doesn't take too long to do, but yes, I intend to cover that. What she's saying is simply, in particularly usually big countries, not too easy to do in small countries, even in Japan. Where can you relocate to Hokkaido and avoid it or something or other? I don't think. And the country's too regulated to do it. But sadly, countries like India have had that, Pakistan even. There are countries where you can move to another place and still avoid the persecution and still get state protection. So that's not, you don't get refugee status. It's a tricky area, but we'll do it as a separate subject tomorrow if we've got time.
So maybe tomorrow we will discuss about these issues. Maybe 10 more minutes, but just for some materials, just kindly brought this Japanese version, translation of the UNHCR handbook of the refugee determination. Unfortunately, this is not updated one, still the bit old one. And I don't know, all of you have already read. This is a translation of the famous Professor Hathaway's book, James Hathaway, the University of Michigan, the professor.
Yeah, we were talking about it yesterday.
That's the right of refugee under international law, the Cambridge University Press. This is a very 1,000 pages one. So we just translated part of the relevant parts. It's a really, hardworking, because his English is too complicated. Even the native speakers couldn't understand well.
Yeah.
So I don't know.
Don't worry, no, New Zealanders can't understand it either.
My translation is correct. Maybe if you found any mistake, you just tell us. I cannot give you, because this is a very expensive one, 3,500 yen, something like that. But if you like, there's some issues, some copies. If you come by our office of the Research Center for Sustainable Peace, you can review. Also, I think this book is also in Komaba, our campus library. And the good thing is this sort of Justice Owada's nice comments. He gave us a very kind compliment of message for this, according to him. Now, the international society for 21st century is a really transition from the legal system centered by state to the legal system centered by human beings. So, in this context, this refugee protection is really the central issues of this transition. And then, what is the international standard for Japan to follow in the protection of refugees? He just expect everyone who are interested in the human security should refer to this book. Nice comment, isn't it?
It's very nice.
In fact, yes?
Yeah, if you go to the Japanese, the portal of the Japanese. Yeah, exactly. That's what was done. Yeah, that's why it's done. It's a little older version, but it's not too bad. Yeah, it was done for Korea, wasn't it, 2014, and that followed on the paper. This one you've got is just an improvement. It's been polished, and because it was rushed, to be quite frank, to have it ready for that conference in Seoul, and when I went back and looked through it, there were a few typos and a few little things that weren't. So that's been polished up since then, and the polished version is in English. The unpolished version is the one that got translated. So apologies for that, but it's I think 98% of it is fine.
Yeah, some Japanese translation a bit weird. For the benefit of doubt, it's translated 灰色の利益. 灰色の利益. It's not so easy to understand even Japanese. What is 灰色の利益? Something like that. Yeah, the benefit of doubt is translated 灰色の利益 about the UNHCR. In general, I don't know maybe this terminology used for the kind of criminal, especially cases, 疑わしきは罰せず or something like that. For the more or less some we don't have any such a benefit doubt of the correct words. So maybe this would be maybe just we trying to interpret in such a way because so it's not so black and white. So this is high in this sense. So if but this is also very controversial things, especially the burden of proof is also the burden of proof,立証責任 for which one will to prove. So level of proof also, credibility of this also.
Yeah, there are clearly now we're getting a lot more decisions from Japanese decisions translated. When you come to read them, the opposite to that in English, there are a lot of problems because, and it's part of the Japanese language where there is a high inference of what we call deference and politeness, and that leads when these are translated fairly literally to an enormous number of negatives. So things are put in the negative rather than in the direct positive, and so you can get sometimes up to about four or five negatives. So not just double negatives, you get 4 or 5 negatives in it, and I assure you, trying to unscramble those for and understand them is just about impossible. That's why the people who are doing the translations and getting them better, and some of them are very good, have to be highly commended to get them into English, because some of them just don't make any sense. You can't work out. There's so many negatives that you can't. And as a person who has really, in training other judges, a great hate of double negatives, if something is something, well, say it is. You don't have to say it's not, I'm not inclined to reach a positive decision on this. What does that mean? So, or just say, I am making the decision. yeah, that's what you want. And I said yesterday, if you want to see good English written that way, go and look at that decision of Brenda Hales on the prorogation Brexit issue. 9 minutes of brilliant English.
Regarding the issues of the linguistic difficulties, I just highlight just a comment that Allan made. Under Japanese law, the international law, the conventions or treaties, even including Convention on Refugee Status, once ratified, by the National Diet, this should be a part of Japanese law. And also, most importantly, Article 98, paragraph 2, if the Japanese domestic law infringed this international law,
Yep.
International law prevail.
Exactly. Yeah.
So in this sense, superior.
Yep.
The convention is superior to the local law, such as immigration and determination of refugee status law. It's a domestic law. So always authorities are very careful to the compatibilities when they propose ratification. So in this sense, all the conventions ratified in Japan is supposed to be no contradiction. But difficulty is international law. The convention is originally English or French. It's not Japanese. But when we understand, in the court practice, always Japanese law, Japanese language is official languages. So that is a kind of a gap in understand. Evidence or judgment or lawyers always understand Japanese version, translations, but not is the origin. Origin is original languages. So in this sense, unless you are familiar with this original language, it's very difficult for the think of the compatibilities or something like that. So that is a special difficulty for the non-English speaking countries for the following. This is maybe not only Japanese problem,
yeah.
For other countries' problem. Once the country has their own language, a public official language, but of course, some country, the colonization, this English should be a public official languages, even though they have native languages. So they have also their own problem for the linguistic. So the linguistic difficulties also attached to this kind of very much complicated.
And that's why we're going to do the last 2 days of the second course, look at comparability between some Japanese decisions and international interpretations of the same issues, which will be fascinating, but again, the translation of it is part of the course. Anyway, thank you very much. We'll finish off
Thank you very much. So
tomorrow. We'll finish off the
week.
real risk the well-founded fear part and the relocation issues, and then we can look at the case study. So please try and read the Bala case overnight. Yeah, tomorrow morning maybe. Okay, thank you.